Plains Angels was started in 2012 and is an initiative of the Greater Des Moines Partnership. The Plains Angels are a group of Midwest angel investors dedicated to providing outstanding financial returns while assisting early-stage growth companies by being an excellent source of funding and advice. Find out more about Plains Angels by visiting www.plainsangels.com.
All right, I think we have a quorum, so we'll get started. We're breaking down our presentation into 3 spots today. I'll start with some discussion about due diligence, corporate governance, and securities rules. We'll take a quick break, and then we'll have a presentation about intellectual property protection from Camille Urban. And then we're going to have a break, short break, and we'll have a panel discussion at the end, and then we'll have some networking and cocktails as well. So feel free to stick around if you have some time and inclination. I appreciate you coming out today. I'm going to make sure my phone is on silent. Just a little bit of background. We prepared this presentation. We did it first in Iowa City and tried to make it very conversational and take some of the questions that we get on a daily basis from companies who are raising capital and answer those questions in a way that works. However, obviously if there's questions that you have or things that you'd like us to discuss, feel free to yell them out. I won't get thrown off, and we want it to be as helpful and interactive as we can. If there's anybody who has an attorney's license who needs CLE credit, we are approved for CLE, and there's paperwork for that over there, which is see at the end. So, I am Joe Leo, partner at Brown Winnick. I spend the vast majority of my time doing securities compliance and capital formation for companies. I'm going to cover kind of the first part of our presentation. So the first thing we want to talk about or address is questions that we get about the due diligence process that you might engage in with potential investors. What it is, how it works, and those kind of things. I always tell people or tell my clients that due diligence is really like has a lot to do with dating in the sense that it's a time where you're going to engage investors for the first time, and all the kind of thoughts that you might have come into your mind when you started dating are the same. First impressions, I find, are incredibly important, and they're similarly typically lasting impressions that investors might have. Regardless of how good your business might be on paper, I think that you can do yourself a real disservice if you handle your due diligence process in a way that's not organized and doesn't make it look like you've got your act together. So let's talk a little bit about what it is and how it works. At a real brief level, due diligence is a process where you confirm material facts about your company, including typically financial information about your company, projections, those types of things. Corporate governance is sort of a broad category, meaning are you organized as a company? Who has which rights? Have you taken the steps that you need to actually form a company? Legal and regulatory issues frequently come up. Certain businesses have a lot of government oversight, so part of that due diligence process is really going to dig in. Do you have the permits that you need to have? Have you thought of all the government entities that might have regulatory authority over your business? And the goal for investors is to ensure that they know what they're getting into. And that's kind of what comes back to this first impressions and organizational issue, is that really investors, they're trying to mitigate the amount of risk that they have by investing in your company. You know everything presumably about your company and should, but an investor is stepping in, they've never had any experience, they might know you or might have had some experience with you, but they certainly do not have the kind of information that they need to know whether you'll be successful. And so this due diligence process the attempt is to kind of shrink that gap between your knowledge and theirs. think one of the most important aspects of due diligence, and something I think the panelists will talk about later, is if you're a company who's raising capital, you need to put some thought into what investors are going to ask for and be ready to answer those questions, which may sound pretty obvious, but I can tell you that putting some thought and asking people who have been through the process before what kind of questions you might get, what kind of documents they might ask for, I think it's going to help you put those documents in some order in your records so that when you get those requests, you can respond quickly. You know, I think that investors get frustrated when you have questions that they think should be sort of at the top of your mind or easy to answer, and it takes you a significant amount of time to do that. And also, I think when you know what kind of questions they might ask, it shows that you know what you're doing. You've done the research, and it provides some comfort to investors. You know, the next thing you should do to prepare is obviously keep good financial records. I think that you know, those are one of the areas that a lot of entrepreneurs don't have experience in accounting issues. They don't, you know, maybe they have a way of keeping their financial information that makes sense to them. And I'm not saying you have to go out and have, you know, a big accounting firm put your financial statements in GAAP, but having some idea on how you would keep your financial statements that it's readable and understandable to an investor, I think is important. And this is, you know, something that we run into is that having those actually in a way that makes sense to people and maybe have been looked at by a third party that makes some sense. Have up-to-date corporate records and capitalization information. I see this as a frequent problem. You know, you're out building your business and doing work, and you know, frequently the thing that gets pushed off to the end is the paperwork that you need, that everyone knows it needs to be done, but is not your highest priority. Before you engage investors, you do need to put some thought into making sure that those records are in place. And especially capitalization information. You know, I think an investor primarily is concerned that A, you know who owns your company and how much they own, and B, that you can communicate that in a way that's effective and makes sense. That's a huge area of risk, and I think it's something that we run into with some regularity, that there's, oh, well, you know, maybe I had this agreement with my brother-in-law at some point where I said maybe if he did this work, I might give him some shares in my company, but I don't really think that he did it, and you know, he might think he owns something in the company, but I don't think he does. Those are the kind of risks that an investor comes in and looks at and says, you know, if you don't know who owns your company, I certainly don't. I think that that's an area of risk that you could avoid. And a lot of that really does come down to documenting any agreements that you might have. Here's another area of significant risk, and I think Camille might talk about it later in the IP section, is if you have employees and independent contractors working in your business, that you have assignments of intellectual property. And those are frequently worked into independent contractor or employee agreements. It's frequently tied to confidentiality, but those are things that, you know, the logic would tell you that if you hire a contractor, if you hire an employee and they do work for you, that you own that. And that's not always the case in the intellectual property arena. And so I think that this is an important thing, and investors know that, and they're going to come in and look and make sure that those, that you actually own the intellectual property that you think you own. And I can tell you that it's a lot harder to get these rights after somebody's already delivered the services than it is to get those up front. And so that's one thing that I always point out to companies, and that's, you know, paperwork that you should have in hand and ready to go. The next thing is to have material contracts organized. And material contracts are any contracts that you rely on in your business. A lot of times I have clients that will do this in some kind of data room. I personally think that when you have those organized well, investors come in and they don't worry that there's contracts out there that they don't know about, or that maybe you have forgotten about. If I showed up at a business and I say, what kind of material contracts do you have, or what contracts you rely on, and they give me a file of information that's half of them are signed or unsigned, they're incomplete. It tells me that, okay, that's sort of sloppy, but I'm worried that there's some contract out there that I don't know about, or that there's oral contracts that you're relying on. And so I think that getting those organized is important to investors. I think that this is One other last point is have information ready about prior investments and investors. That sort of comes in the capitalization table, but if you've cut deals with people before, or you've got other investments, a lot of times investors will want to look at that, make sure that it was done properly, and that you have sort of your ducks in a row. Is there any questions about that? So that's sort of the broad overview on what kind of preparation steps that I think that you should take. Kind of the summary of what records should you be keeping. Obviously, here's a list of records that you'd want to keep, but I take it a little bit further. Those are the kind of records that you want to keep someplace handy that you can deliver sort of at a moment's notice if asked. Those are the kind of things that I think a lot of investors wouldn't expect that it would take you a month and a half to put that information together. So if you're going to go out and raise capital, I'd start pulling that kind of information together so you have it handy and can deliver. One thing about capitalization tables or cap tables that I always like to point out, we did, I think, a pretty good summary of that for Plains Angels. I think the video is on the website, but a lot of times people don't understand that those tables should also include options and other rights to acquire equity that you might have out there. And I think that that's something, if you haven't put any thought into, you ought to do that. Frequently you just discuss cap tables that are fully diluted, showing, if everyone today exercised their options, how many shares would be outstanding in your company. And a lot of times I see cap tables that don't encompass that information, which I think is a problem for investors, obviously, and it's a question that you get. So you might want to put some thought into that and make sure that you're presenting that in a way that makes some sense. Any questions about that? All right. So the next kind of broad topic that we want to talk about is corporate governance issues. And at its most basic level, corporate governance is essentially how your companies are organized, and from a legal perspective, and it's really the rights and responsibilities of the people that are investors, directors, officers of your company, all fall under this umbrella. So this is a question that we get a lot from companies. I need to be a Delaware C Corp, right? And in keeping with the theme of answering those questions, it really depends. And I know that people get irritated when they hear that kind of answer from their lawyers, but it does. Every company is a little bit different. There's typically no absolute right answer for every company. There's usually some options and some pluses and minuses that you get. Kind of the pluses that you get when you go with a Delaware company is that they have a very established set of corporate laws, and they have courts that are able to analyze problems that companies get into frequently. However, what's sort of hedged in that is that most courts, if they've not seen an issue in other parts of the country, they look to Delaware law to tell them how they should analyze it. So in the old days, you always kind of wanted to be in Delaware courts because they had the best court system to deal with corporate law issues. Now I think that with the ready availability of that information to other courts, it's sort of taken away some of that charm. There's a significant cost to being a Delaware company, and in some cases that's beneficial, some cases not. The second part of that question really comes into what kind of company you want to be. So, the most common types of companies that you'll see are a C corporation, an S corporation, an LLC, and some older companies will be partnerships. So, what are the benefits of those? A C corp it allows you to defer taxes as an investor, which isn't imperative for you as a company, but frequently we'll see investors who come in and say, I'm not willing to invest in another form of company because I don't want to pay taxes on earnings that I don't get in cash. So does anyone here have an LLC that they've set up? Okay. So at a real broad level, an LLC is what's called a pass-through tax entity, meaning that at the end of the year, the owners of the company pay taxes. The company itself does not pay taxes. With the C corporation, it's the exact opposite. The company pays taxes on any income that it has, and it doesn't pass through the income to the owners. So why that's important to investors and why you might think that I want to switch to a C Corp from an LLC if you're taking investments is frequently larger investors aren't going to take the risk that you're going to allocate income to them without corresponding cash. So most investors don't want to be paying taxes out of their pocket if they haven't actually received any cash. And that's sort of the biggest risk that we see with LLCs. Investors that are less sophisticated or don't have this kind of size of investment, they might be willing to do those because there's some beneficial tax aspects of being an LLC. But this gets really complicated really quickly, as you can see. That's sort of a loaded question, I would tell you. The one thing that I do want to point out and that I see as a frequent problem is S corporations. Does anyone here have an S corporation that they've set up? Okay. So hopefully you're aware that there's limited numbers of kinds and numbers of investors that can be owners of S corporations. So for instance, if I'm an LLC, I can't invest in Mike's S corp. It's illegal. There are some benefits to having an S corp in certain situations, but that's the one thing that I would tell you if your company is set up as an S corp, be very cognizant of is whether you're taking investments from somebody who's not eligible to invest. Those are, like I said, a lot of times my clients will opt out of being an S corp if they're going to raise capital, any significant amount of capital, just because it's too prohibitive. But it might make sense, while you're getting started up or for certain kinds of businesses. Any questions about that? I know the tax formation issues are always the most exciting. Kind of going from there is that you can get the same tax effect of being an Iowa C corporation as you can with a Delaware C corp. The tax rules are sort of mostly at the federal level, the difference, but that's one thing that you get into. Certain in Delaware, if you do business in other states, there's some favorable tax aspects of being a C corp there, but I don't think in Iowa you're going to get the bang for the buck that you'd like. There's significantly less fees to being organized in Iowa than there is Delaware. Delaware makes a significant amount of money on the fact that they maintain this sort of active amount of corporation courts. So that's one thing to consider. On the other side of it, certain investors see that as something that they're comfortable with. They know the rules, especially if you've got out-of-state investors. So that's one thing you might think of. Certainly, you can always convert to a Delaware C Corp later if that makes sense. A lot of times you'll see that before a company does an IPO that they'll convert to a Delaware C Corp, especially if they're taking money from sort of outside of Iowa. But those are kind of the pluses and minuses. I know that there's many rabbit holes that we could go down there, but it's sort of a loaded question in the sense that it's not easy to answer without knowing your specific business. Are there any questions about formation? Does anyone have any specific formation questions?
Can an LLC be converted to a Delaware C Corp?
Yeah, yes. So it's very easy to, companies that are what are called pass-through taxation companies, so a partnership, an LLC, an S Corp, are easier to convert to a C Corp than the other way around. So if you form as a C Corp and then you want to go back to an LLC because there's better tax treatment for the LLCs, it's frequently a much more complicated transaction. But it's very easy to convert an LLC to a C Corp, either Iowa or any other state. And so I advise clients frequently, if you think that you might need to be a C Corp at some point, it's fine to start off with an LLC. That's probably the easiest way to start. And then down the road, it's pretty easy to make that conversion. Not so much to go back the other way. So,
how do you know when you should be doing that? At what level monetarily or something that tells us when we should be doing that?
So currently, I represent LLCs that have 1,300 members that do, $400 to $500 million in revenue a year. So you can certainly be a very big LLC. The times that you don't want that is, a lot of times investors will drive that decision. They'll come to you, and because of that, the issue of the phantom income, a lot of times you'll hear is the term used, which is, if I'm going to invest in your company, more than likely you're going to be dumping all of the extra cash that you have back into the company. So if you make money, all of a sudden I've got a tax bill to pay with cash. And so a lot of times that drives the decision, is that they'll say, I love your business, but I'm not willing to take that risk. And so that's the time that I see it. Certain times you might have industries where it makes more sense, but for an LLC versus C Corp, anyone can invest in an LLC. It really comes down to that tax allocation issue. I would let the investors drive it, quite honestly. So, but like I said, the bigger the LLC gets, the more owners, the more complicated overhead that you have associated with it, but you certainly can be a big one. Are there any questions about that? The next kind of hot topic that I want to talk about really briefly is stock options and option pools and kind of what those are and how they work. So at a very basic level, a stock option is the right to purchase a stock at some point in the future based on specific terms. It's a contract that you have. There's a number of different ways that these can be structured. There's incentive stock options. There's stock options that can be issued to other investors to kind of let them capture upside. There's a ton of ways that these can be done, but at the most basic level, all it is a right to purchase stock in the future at some price. So the idea being, if the stock increases in value, you would exercise the stock option, you would pay for whatever you agreed to pay, but at that point you've kind of got built-in gain. If the company goes in the toilet, it's not worth anything, you just never exercise your option, and it allows you to sort of have the upside without having to put money up front. Frequently you use these to incentivize management teams and other employees are a way that we would use those, but it's not just limited to kind of those incentive situations. Typically these stock options are going to be subject to vesting requirements, so especially with employees you might have some time period vesting requirements, or if you're developing a product, maybe you tie it to development stage of that product. And that's typically how we would see those issued to employees, but for other investors, sort of the sky is the limit as far as how you want to do that. The only tricky part to them is that they, the tax rules change based on who the holder of the option is, and so you want to make sure that you really spend some time formulating those plans so you don't have unintended tax consequences. So that's what an option is. Does anyone have any questions about what an option is or how it works? Okay. So these are typically set up as a stock option pool. The reason that you would set them up as a pool, basically what a pool is a restriction on the amount of stock options that you can have. So remember back to when we were talking about due diligence, about fully diluted cap tables and rights that might be outstanding where somebody can come in and exercise those rights and issue more shares. This is tied to this idea of a stock option pool. Is that when you have a pool, it limits the number of options that you can have outstanding without going back to the shareholders for approval. So if I'm investing in a company and I come in and they have an unusually large stock option pool, in my mind as an investor, I immediately go to, if this goes well, all these employees or any contractors, remember they issued a stock option to, they're going to all exercise their option and it's going to cut into my interest in the company. And so it's important when you're forming these stock option pools that you're realistic and you think through how an investor might think about the size of that pool, maybe how you're using it to incentivize different people. They can be powerful tools, but they can also make investors really nervous because really what it is built-in dilution for them. Setting it up as a pool minimizes the potential dilution. As an investor, I know how much dilution I'll have to stand for if all those options get issued. And like I said, investors don't want a lot of options out there because it dilutes the value of their interest in the company. So real basically, here's a couple of best practices. There's no written option plan. The board of directors can issue as many options as they want. I think that this is a bad situation. Even as the company, I don't think that you want to have that sort of broad rights because investors are going to look at that and it's going to make them nervous. Keep in mind that the shares are not actually issued to the option pool. They're just the rights of the board to issue those options at any time. and so they just sit there. If you don't use them, there's no actual shares outstanding. And the actual option holders only get ownership in the company when they actually pay for the options. So, typically with an option, you've got a strike price, which is the price that you have to pay to actually buy the shares. And we'll talk about how that works in a minute. So here's a very, very kind of basic cap table that we put together that sort of illustrates this. Is that in this case you had a founder who had 80,000 shares in the company. They brought in investors for 20,000 shares. So obviously with those two groups, they've got 100% of the company, 80% to the founder, 20% to investors. But they've also got an option pool for 20,000 shares. And what does that mean? Well, as of this time, it means nothing. None of the shares are outstanding. An option pool is just there. It's shares that could be issued at some point if people exercise the option. But an investor is going to look at this more like this situation. They're going to say, okay, that's great, but if this company does well, which we hope that it will, all of these people are going to exercise their options. And they're going to go from owning 0% of the company to essentially the same amount that I own as an investor. Maybe that's a good deal, maybe it's not. But those are the thoughts that you have to put through, is that take that next logical step of an investor is going to be looking at this on a diluted basis. So, putting some thought into how you do those option pools, I think makes a lot of sense, especially up front. Any questions about that?
How did you deduct to get to the diluted number? If the options come into play?
Yeah, so in this one, what we have is, we don't have 20,000 shares here, we have options to purchase 20,000 shares. And so on a diluted basis, you would assume that all of these people exercise their options. They bought into the company, and now we've had, instead of having 100,000 shares outstanding, now we've got 120,000, and that's kind of how you get to those numbers. And it gets a little more complicated because if you've got a very high, what's called strike price, that might make a lot of sense because people have to pay a lot of money into the company in order to get to buy those shares. But it can, in this instance, especially if the strike price is really low, it could be a lot of dilution. An investor might say, I'm not interested in, with that amount of stock options out there, I'm not gonna invest. But that's how it basically works, is that you assume that all those become outstanding shares.
Joe, any difference between option pools and LLCs and C Corps?
No, they work essentially the same way. You've got, and I have to look at the tax treatment. I haven't looked at that recently, but an LLC has the right to issue options as well. They would go in the same way that a corporation does. And I think that there's and you're testing me on my tax knowledge, but I do think that there is a more negative tax impact for LLCs if you don't structure them in a specific way. I'd have to look at that again. But no, they have the right to do it, and it's the same kind of thing. A lot of times with LLCs, what I suggest too as an option is phantom stock plans, which are contracts for your employees that mimic ownership of equity in the company, but aren't actual equity. And so some of my clients use those just because it pulls the owners out of the equity situation and also avoids some self-employment tax issues that kind of can come up if your employees own the company. So, but no, LLCs can certainly have options as well. Okay. So next kind of mini topic that I want to talk about is valuations, dilution, and investor rights. I get this question frequently. I am certainly not the best person to answer it. And the question is, how much is my company worth? You see a lot of these things. What do you think it's worth? I tell people that, my dad, I remember when I was a kid, I was talking about my baseball card collection and how much it was worth. And my dad taught me an important lesson. He said, your baseball cards are only worth what somebody's willing to pay you for them. And that sort of advice comes, full circle with how much is my company worth. Valuation, there are certainly metrics that are used, there's logic that is used, but at some point it's a negotiation and that companies engage in. If you're good at negotiating, you probably get a better valuation. If you're not, you're probably going to get a lower one. And there's certainly, I don't want to give you the impression that this is, complete, throwing a dart at the wall, but I can tell you that that there is no, magic formula that you can use for your business that'll give you a valuation. Like I said, there are professionals who can assist you in making the determination of valuation. There's not a one-size-fits-all. There's probably some companies that are, maybe franchises and things that have a little easier way to value them based on some metric, but for most companies, those aren't that helpful. And like I said, it's subject to negotiation, which can greatly impact the value. There's two kind of time periods when this is important. There's a pre-money valuation and a post-money valuation. Pre-money is a valuation that you use sort of as an internal planning tool to determine how much you're going to go out and the price you're going to fix to your equity when you go out and sell it. So, frequently that's just agreed upon by the existing members or shareholders of the company or the board. And really, this is the most internal looking as far as the company goes. And it's used as a planning tool before you go out and raise capital. So people sit around the table, they say, what do you think we can raise money at? I think it's $2 a share. Maybe somebody else thinks it's $2.25. But this is the company's own kind of internal feel for that. Don't get married to it because frequently it's going to be negotiated at some different level. The post-money valuation is what you take as far as the valuation of the company beforehand, and then how much equity you actually raise or cash that you raise. So, this is more formulaic, but it takes into account the negotiations that you might have with investors. So you might have started at a $3 million valuation. Maybe your investors worked you down to a $2 million pre-money valuation. They put in $3 million, and all of a sudden you've got a $5 million valuation. So the example I think that this is helpful to kind of keep in mind is company has 1,000 shares outstanding, and they plan to raise capital and offering for $2,000 a share. Maybe they want to get $3,000 a share, but they decide 2,000 is our number. So with 1,000 shares outstanding, $2,000 a share, their pre-money valuation is $2 million. They've decided that their company is worth $2 million. We're not interested in the amount of capital that they actually are going to raise in the offering at this point. You just are basically taking the beforehand valuation. How you would calculate the post-money valuation is that you have the $2 million pre-money. The company conducts an equity offering. They raise $3 million from investors. Say they did really well in their negotiations and they got the price that they were looking for. Their post-money valuation is $5 million. So $2 million pre-money, $3 million in equity. The value is $5, which only is probably instructive as of that day, because the next day it could be different, and a month from then it will probably be different as well. Next time you raise capital is probably different as well. But that's a term that gets thrown around. Any questions about valuations? I mean, it's more complicated than I'm making it, but that's the basic concept of it. Okay. So dilution, what is dilution and how does it work? Dilution is, I always like to tell clients to think of it in two ways, is that dilution can be both an economic interest and a voting interest. And sometimes companies will break those two apart. So don't always think about it in the same way. But it's your reduction in a percentage ownership of a company that you suffer because of subsequent rounds of financing or new people coming to the company. So day one in my company, I own 100% of it. I bring in Eric and take some capital from him and offer him 50% of the company. I've now diluted my interest by 50%. So anytime you bring in new investors, you experience dilution. And the idea being, hopefully, when you bring in these investors, the company's worth more, and it made some sense. I always ask people to do an analysis of the rights and their ownership before, both from an economic and voting idea. Certain times with investors, you'll give them preferred voting rights, and that'll impact their dilution from a voting standpoint. Any questions about that? All right, I'm going to
down round.
Yeah, I'm sorry. And I am skipping through a couple things. A down round is basically where you sell equity for less than the amount that you sold it previously. And that can really increase your dilution. So say you raised $2 million at $2,000 a share, and all of a sudden something bad happens to your industry, and now you're selling shares at $1,000, but you need another $2 million to re-up. Those are really can hit your dilution percentages and dilute the prior owners, because you've really, the value is significantly less. So that's referred to as a down round, I guess that stands to logic that you're selling equity for a lot less, but that's where we see them a lot, is the dilution percentages go up significantly. Any questions there? Okay, so preferred stock, everyone's heard of this. I want to give you just a couple of parameters to think about. Essentially, preferred stock provides some right or series of rights that are greater than the common shares. And these are all relative, so keep that in mind, is that preferred is just in addition to whatever the common person has rights to. This can get very complicated. I would suggest, as far as before you raise capital, try to limit to whatever extent you can the preferred rights that you give out. Sort of the old adage is anything that you give in this round, you're going to give in the next round plus something else. And so if you kind of give away the farm early on, you can really kind of back yourself into a corner where you don't have anything to offer. And also, I think that investors get nervous when it gets too complicated, when you've got all these people who have different rights. So be very careful when you're issuing these preferred rights to different shareholders. The most typical preferred rights that you can see are what are called distribution preference, liquidation preference. I'll go through these in a minute. Board appointment rights and veto power or appointment rights to a board, and a right of first refusal. So preferred dividend basically allows certain investors to receive either a larger or an earlier distribution of cash from the company. So these are frequently written in a way of saying, I'm a preferred shareholder, I get a 5% distribution before anybody else gets anything. And those can be annual, it can be longer periods, but it allows me to get paid first or allows me to get paid more. And that's where it gets kind of complicated, and you want to run some scenarios before you give those preferred distribution rights. Because it can really affect kind of the economic rights of the other people. And sometimes you can back into a situation where you're really sort of unhappy. So be very careful with those, but that's basically what they are. The second kind of preferred right that you frequently see is what's called liquidation preference, meaning if we sell the company, and hopefully it's a sale as opposed to just shutting it down. If it's a shutting it down, nobody really cares, but you sell the company, who gets the first money out of that deal? A lot of times preferred shareholders are going to want to get their investment back, plus some guaranteed return back first before anybody else gets anything. So that's another preference that we see frequently that can be used. A cumulative preferred dividend means that if you didn't pay your promised dividend in prior years, that you have to make that up before anybody else gets a dividend. Those are, like I said, that's frequently how they're written, meaning if we have a bad year, last year we didn't pay any dividend, maybe you need to pay your 5% last year and 5% this year before anyone else gets anything, including the founders frequently. The third type that you'll see is a participating preferred dividend, which means not only do I get my preferred dividend, but I also get the same dividend that all the other common shareholders have. This is, like I said, I think that if you have these outstanding, you're going to have a hard time raising capital from investors later, because that's, it's sort of a typically high hurdle to get over. So I'd be a little careful as you kind of start stacking these rights on top of each other. Any questions about that? Okay. I know I'm flying through, so if there's something that you want to talk about, let me know. But the next kind of big topic that we get a lot of questions about from companies are, what are the securities laws and the compliance requirements that we need in order to raise capital? So, I frequently get this question, from whom can I raise money and how much? This question is most easily answered by, depends on how you want to raise that money. Most companies start with a friends and family round. Who's raised money from friends and family? And I'll leave out the last part again. So you know how that goes. It either goes well or you have, an open Thanksgiving for the rest of your life. But, here's what I like to tell clients though is just because you raise capital from friends and family does not mean that there's no rules that apply. Frequently you don't have any government oversight or securities law compliance that you need to do. But keep this in mind, is that every offering of equity in your company that you've made, there are laws that apply, and there are ways that you can trip yourself up down the road. Be cognizant of how you do that. So the basic limitations are that you need to comply with both federal and state securities laws. In most cases, those laws work together and are complementary, and in some cases, they're not. And this is one of those instances where a little planning up front can really help you down the road. Generally, the rule is either you have to register with the state and the federal government, or you need to find an exemption from registration. Almost nobody registers offerings. It's too expensive, it's too time consuming for most companies. They don't go through the process. And especially in Iowa, there's very few companies that are that meet that standard. I can tell you that I have several companies that are SEC registered, and I think that the conventional wisdom is that it's, for your first registration, it's probably $250,000 to $500,000 just to get through the registration process. So most people aren't going to be raising enough capital to have that make sense. And as I said, for early stage companies, it's too cost prohibitive, so almost all rely on exemptions. Frequently, whether an exemption is available depends on whether the investors are accredited. So the general concept is that the SEC and the state securities regulators are much less concerned about higher net worth investors than they are your typical, everyday investor. They've decided that people who have more money are more sophisticated in their investments. I don't know if that's always the case, but that is the standard that they use. So basically, an accredited investor is individuals with income in excess of $200,000 for the prior 2 years and a reasonable belief that they're going to reach that level in the current year. And it's $300,000 for married couples. The second most commonly used accredited investor is somebody who has $1 million or more in assets, excluding the equity in their primary residence. And there's various business entities with more than $5 million in assets are accredited. Now there's a whole list of other people, but this is the ones that you're going to run into most frequently. I can't tell you that it's the Wild West, that no rules apply, but if you have investors at these levels, you're going to have a lot easier time raising the money that you need. The interesting part from my perspective is these numbers were set in the early 1980s, and I know that $1 million in 1982 is not $1 million today. So the good news of this is your landscape of potential investors goes up every year. Now, there's some feeling that they should increase these limits, but I do not get the sense that that's going to happen anytime soon. So, from the federal perspective, the most commonly used exemptions from registration that we're talking about are 504. These all refer to the code sections, and it's just lawyer speak, but unfortunately it's kind of pervaded the investing public, so most people know what these are. 504 is for smaller offerings up to $1 million. There's essentially lower compliance requirements for those. There's 506B and 506C. And now this is a recent change that came into effect this year. But 506B, this is the most commonly used exemption, probably in the past, or certainly in the past and probably currently. It allows you to raise an unlimited amount of capital from up to 35 non-accredited investors. So remember, we talked about the accredited high net worth. This allows you to take money from 35 people who don't meet those those requirements, and an unlimited number of accredited investors. From a practical standpoint, though, lawyers are going to tell you that even though you can raise money from non-accredited investors, there's additional steps you need to take, and it's really not a good idea from a practical standpoint and from a liability standpoint. I always suggest to my clients that they only raise from accredited. 506C is a new offering exemption. It allows you to raise an unlimited number of capital, or amount of capital, but only from accredited investors. And there's no restriction on general solicitation and advertising, which was kind of the old hallmark of the 506 and other federal exemptions, is that you couldn't advertise your offering. You couldn't put posts on Facebook, you couldn't put an ad in the newspaper, you couldn't be on the radio, and people were really nervous about whether you had made some kind of advertisement. Recently, they've come up with 506C. It restricts the kind of investors that you can have, but you can solicit and advertise as much as you want. But they added one other wrinkle, is that you have to take additional steps to make sure that your investors are accredited. In the olden days, what you would do is you just take a questionnaire from your investors, and so long as you reasonably believe that they're not lying to you about their accredited status, that was plenty. Now the SEC is saying you got to take additional steps, and they've been somewhat vague about exactly what those have to be. We'll talk about that. Some people are more nervous about that than others. I personally think it sort of makes a lot of sense, and it's kind of how the industry is going. But that's the difference. The final one is an intrastate offering, and this basically says if you only offer your equity in one state, there's an exemption from federal securities laws. The problem is that with the internet and the way people do business, there's not a lot of offerings that meet that exemption. Any questions about that? Okay.
Actually, Joe, go
Yeah.
back.
Yeah.
So when you start your round of raise capital, do you have to pick your exemption at the beginning and stick with it?
So typically you can make several of these work depending on how you do it. I always kind of suggest that you would go out and have kind of a plan. Frequently it's between these two, but you don't need to make a filing and say absolutely this is all we're going to do from here on out. Because if you qualify for any of these exemptions, you're fine. Typically my clients will have a plan going forward, but so long as you hit one, then you're all set. So, and these are at the federal level. There's other ones at the federal level you can use, but I usually advocate having a plan. But like I said, if you start at this level and all of a sudden you say, hey, I'm going to raise $2 million, not $1 million, so long as you qualify for these ones, you're probably okay.
I've heard that a lot of people are still nervous about the new exemption simply because they haven't been litigated yet. And could you comment about that?
Yeah, I think that nervousness, I think will hopefully subside in the next, few years. I don't think that this is actively going to be litigated that much in the near term, unfortunately, for the people that are nervous about that. The problem is that the SEC was somewhat vague about how they wanted you to certify these accredited investors. But I think that if you read their releases that the SEC put out, they were intentionally vague about that because they wanted people to take kind of a practical approach. Now that makes some lawyers nervous, and most business people though are willing to take some level of risk. I don't see the SEC out policing this very, very much. I think that I think as time goes on, best practices will kind of emerge, and I think that so long as kind of companies are reasonable in what they do, I don't think that they'll have problems with the SEC. Now the real risk that I see is states also have, while they're not allowed to separately regulate these issues, they potentially could bring enforcement action saying that you didn't meet those rules. And that gets to be a little bit of a wild card because you have certain state regulators that, like anything else, are sort of out to lunch a little more than others. And that's what I almost worry about. The SEC was very specific on why and Congress, I guess, on why they put this into 506. From a legal standpoint, they shoehorned it into another exemption. The reason that they did that is because there's a statute that says the states are not allowed to separately regulate these 506 offerings. They can only require you to pay a filing fee and make a state filing. And so the reason that they did that is exactly what you're saying, is that they're trying to take it out of the hands of these state regulators, but it's impossible to do that 100%. So I guess that's the thing that keeps me up at night a little bit more, but I don't see a big push where people are getting that question. one of the things to think about, and I think I'll go through this, I think it's one of my next slides here, is that the steps that they really require you to take, there's some practical ways where you can sort of put yourself firmly in the rules, and I don't think that they have a good argument. Good question, though. Any other questions? Okay. Like I said, at the state level, we talked about that there's federal and state requirements. As we talked about 506 offering to the ones that are based on that, there's a qualification in each state because of that statute, and so states can't separately regulate you. That's why most people rely on the 506, is that you don't end up in a situation where you go to some state and you find out that you can't raise money in that state for whatever reason. There's also state accredited investor exemptions. So for example, in Iowa, if you have an offering to accredited investors, that's exempt. And a lot of states have that in it's sort of a model statute that Iowa has. So a lot of states will have that. Some states put conditions on it because they want filing fees. Pennsylvania is awful for that. I don't know why. I have a client that raises money every time from an existing shareholder in Pennsylvania, and they require us to pay like $1,000 filing fee for something that I think is, fairly ridiculous. But in Iowa, you don't have those kind of things. Various states also have small offering exemptions if you're not, raising a lot of money in their states. So the states are typically not difficult to find an exemption, but you usually do have to do a little bit of digging to make sure that you're getting the best one before you can. Like I said, if you can qualify for these state exemptions, sometimes there's no filing fee, so it's worth kind of pursuing. Here's kind of a best practice. I guess the question that I was keying off of is, what do I need to disclose to my investors when I raise money? Under these exemptions, especially the 506, and when you're involving just accredited investors, the legal answer is nothing. You don't have to give them anything. The practical answer is that is a bad idea. You want to give some level of disclosure, either a private placement memorandum or a term sheet. Private placement memorandum is quite of a bigger offering document. It looks kind of like a registered offering. More work, more expense, but it's kind of, it's something that some people are willing to do. Most offerings do a term sheet, which is a much more abbreviated process. It relies on, typically a company's business plan as an exhibit, and the term sheet itself just goes into the legal requirements. You need to give your investors something, and the reason for that is as I state here at the bottom, more disclosure is cheap insurance, and it is. If you get into a fight with your investors, it's really handy to be able to say, okay, I understand that we've had a bad year, but if you'll notice, I talked about the risks that we faced, and one of them was, we might not be able to find a supplier that we need or whatever. And so I always tell clients that as painful of a process as this is, it forces you to sit down and look at your business and figure out what the risks are from an investor standpoint. I think investors, when they look at this, they realize that you've gone through that thought process. Certain ones will be scared off about the risk that you put in, but I think that that's better than bringing them in as investors and then having them, bring an action against you, say you lied to me about X, Y, or Z. Typically, what's included is a detailed business plan, legal disclosures about their rights being sold. So if you're giving them preferred rights or other people have preferred rights, those typically get disclosed in a term sheet or a PPM. Identification of the material risks that your company faces. We could get swallowed up by this competitor. Our market might change. There's some standard ones. There's some that are really tied to your business, but that's what's typically included. And the final thing is an actual agreement between you and your investors that they're going to invest money. And those are typically referred to as a subscription agreement. All right, I'm just keeping an eye on my time. So here's one other issue that I get questions about. What is crowdfunding and how can I use it? I'm going to try to not color this too much with my feeling about crowdfunding, but or maybe I should, I don't know. Here's the thing, from a practical legal standpoint, Crowdfunding is not yet legal. Some people have missed that part of it. The SEC has been directed to pass rules on crowdfunding, and the statute specifically says that until those rules are passed, it's not legal. So, it's out there. The SEC, I would say, is dragging its feet on issuing those rules because they have concerns about crowdfunding, not different than mine probably. Basic idea is that it's like Kickstarter but with equity in companies instead of pre-sale of goods. And so, the idea would be is that you would be able to buy a small interest in companies that advertise sort of over the internet. The SEC is trying to put together regulations about what those marketplaces look like, what kind of information they need to be provided, that kind of thing. I will give you, since I've got 3 minutes, I'll give you my feeling on those. The practical advice I give to everybody, regardless of when these rules come out, is if it were me, I would only do redeemable equity through through crowdfunding. Reason being is anybody who's had a company where you've dealt with outside investors before can probably name their 5 worst investors that call you, complain the most, want you to address whatever concerns that they have. And sometimes those are legitimate, sometimes they help, and sometimes it becomes a huge time waster for you. Most people can deal with that if the person wasting their time wrote them a $100,000 check. Most people cannot deal with that if the person who's wasting your time wrote you a $100 check. And I think that these crowdfunding kind of offerings are going to end up with thousands of people who have given you $100, and then you're sending them financial statements once a year. If you're an LLC, you're issuing them a K-1 for $35 a year. You are potentially having people who can sue you for securities fraud because they say you follow these rules, but they can still bring any claims, and you've got your anti-fraud rules and all those things that you have when you raise money. So now instead of having 20 investors, you've got 1,000, and I don't know about you, but sometimes you just pick wrong on who you take money from. And so that's what makes me nervous about crowdfunding. And I think if you structure it as a redeemable equity, if somebody is sort of not worth the trouble, it gives you the right to buy them out at your option at any time based on some formula that you've put together so that there's no argument. But I think if you don't have something like that, my worry is that you're going to have a whole bunch of costs built in that wasn't really worth the headache.
Yeah, I looked at 5 fashion crowdsourcing companies this week, and they want me to send them my product, and they're only going to give me 30% of what I earn anyway, if I even get it, for me to even start my products. That's not even worth my time.
Yeah.
So, and there's I still have to get insurance for all that, and investors aren't even going to want to waste their time with that. So my advisor said, put the product out there as soon as I can get it. It's not even worth it. Sell it on my site instead.
Yeah.
So I don't think, that's even worth the time, like you said. Pre-sales, I didn't even know that it wasn't legal, so I think that the pre-sales, are scary for me to go into, but I thought it would be a great thing, to do, but if I can get it on my site a lot sooner, that would be better than using these fashion Kickstarters instead.
Well, and pre-sale of goods is okay, but you can't sell ownership and actual share in your company.
Right.
And I just think it's, that's always been good advice, is that if you're, sometimes shareholders, if they make you nervous before they've written you a check because of their demands and things, and or their inability to understand the risk that they're undertaking, certainly does not get better the minute you cash their check. So I just think this expands the number of people who might have a problem. Are there any questions? Go.
So the subscription agreement, what type of info is captured on that?
So it typically has, the way that they're structured is pretty straightforward. You give me this amount of cash, I give you this number of shares with these rights, and it typically refers back to your PPM or your term sheet that you have. A lot of times, then it goes through kind of a whole series of representations and warranties that say, investor, you have reviewed our business plan, you've reviewed the term sheet, you want to, you are who you say you are. I mean, there's fairly far-flung ones. You're not investing based on drug money or in furtherance of a terrorist group, and, all those kind of fun things that people ask me about. And but it's a financial transaction, so it's typically a whole series of those. And then part of that is also, depending on what kind of offering you have, a questionnaire that asks if you're an accredited investor, and so you ask them to certify, yes, I meet these requirements and those types of things. And so that's what it looks like. It's usually 13, 14 pages, and most of that's instructions in this questionnaire. But it's the final contract that says that they agree. Great, life.
Joe, mine's a bit naive, but I've wondered about it since the show started. How are the ownership positions couched on Shark Tank?
I don't know what their actual deal is, but I think they have a pretty...
negotiated in advance of the occurrence, are they?
I don't even know. I thought it was kind of a flat deal, whatever they gave you. Is that not right?
I know there's just a ton of paperwork that.
I know somebody that went through the whole process, and it's an obscene amount of paperwork. It is very one-sided, and the person went through it, so there's no way I'm signing any of this, and walked away from the deal.
Yeah.
So it's not simple. I know they've been trying to get it simpler. Cuban threatened to walk away from the show if they didn't make it simpler, but I haven't heard what happened after that.
But it's a kind of a take it or leave it deal, right?
I
And it's all-
applied, at one point it was, you had to sign away percentage all the time, but now they changed that, where whether you got on or not, they don't take that. It used to be, you gave away 4% no matter what. So it's not that anymore, but it's still changing. So that's the last I heard of it, but.
Yeah. Those are the kind of things, if I was an investor coming in later, that you'd see and you'd kind of throw up your hands and say, I don't want to wade through this and know what your Shark Tank is. But it was my impression that they asked for a certain percentage, and it was kind of take it or leave it. So I'm sure it's good at advertising for the people that do it, but my guess is that it's better TV than it really is. Get to the heart of your product. But I don't want to paint myself as being too cynical. I think I've already done that. Well, I think it's break